Welcome back and thank you for staying with Weekend Prime. Now, let's get to the conversation. As I had mentioned earlier, my guests are here with me in studio. Willis Otieno, an advocate next to me, and to my far left, Dr. Maxwell Miawa, scholar and equally an advocate. Good evening, gentlemen, and thank you so much for making time.
Good evening. Thank you so much.
Let's start with you, Daktari. So is it Daktari or Wakili or Daktari Wakili?
Any can do.
Any can do. Yeah. All right, let's start with today's events. I mean, it's been a busy day. First, President William Ruto nominates CS, that is Interior CS, Professor Kithure Kindiki, and then the MPs vote in favor of that particular motion. And then on this other hand, the courts issue temporary orders stopping the replacement of Rigathi Gachagua. I mean, many are saying the fact that that particular order came just a few minutes after that motion was, if for lack of a better word, was approved by the National Assembly, then perhaps it was overtaken by events. Is this the case?
That is actually sort of, there's a half-truth to it. In the sense that the order came after what it sought to stop has already taken place. For instance, they sought to injunct Parliament, the Senate from giving effect to National Assembly's decision. And by the time the order was coming, the Senate, the National Assembly had already taken a decision on the basis of the Senate's decision. So it cannot act in retrogression, you know. It cannot act retrospectively because orders don't act retrospectively. I think the problem really is to blame the lawyers who drafted the petition, who drafted the application of the orders, so that they could have even sought to injunct much more than just giving effect.
Yes.
One of them would have been to injunct the swearing in, the oathing of the deputy president nominee, and even assumption of office. Okay? So you can see that those have not been injuncted, which of course they can still go on.
Yes, but that was done in Kerugoya.
Of course, now you can see the lawyers in Kerugoya were much smarter than the ones that represented the DP in the High Court in Nairobi. So if you are to go by the decision in the Kerugoya one, I think then the process has effectively been injuncted.
Okay. Coming to you, Willis, of course, with everything that has happened, I mean, there's so much. Kenyans are trying to, break down the law and understand what it means. So let's take a look at this order that Gachagua's lawyers are saying that it means that the deputy president remains in office until that particular court hearing. How does this happen, considering on one end, we have already an approved nomination, and then we have a former deputy president with a court order? Where does that leave the country?
Maybe I should start the conversation by saying this.
Yeah.
There's only one deputy president of the Republic of Kenya at the moment, and that will be Rigathi Gachagua. Despite my dislike for him and his politics, but I love the law more than I don't like Gachagua. So let's just be factual and apply the law as it were. Once the High Court gave orders stopping the implementation of the resolution of the Senate, that order applies from the time when the Speaker of the Senate stood up to speak, to read that resolution. So we go back to the status quo ante that was there, that was prevailing before before the Senate Speaker stood up to read its resolution. And further, we need to understand this. Anything that is done contrary to the Constitution, by itself is illegal.
Okay.
So any process that has been done contrary to that law, and more so because the object of the order was to make sure that the office of deputy president is not occupied pending the determination of the petition. That is where we are. So nobody can occupy that office. And Gachagua, since he has gotten a stay of the resolution that led the National Assembly to discuss the nomination of Kindiki, he remains the deputy president, despite anybody's individual opinion or view of the gentleman and his politics. Give him his dues. Then, what we are witnessing now is this, the question of now even the nomination of Kindiki. That is an independent course of action In fact, independent even of the proceedings that Gachagua and the other petitioners who filed in court are pursuing. Independent in the sense that it starts with one thing. Number one, the president nominates. And for him to nominate, the person so nominated must meet the minimum qualifications to become a deputy president. And if you go to the Constitution, the nomination of a name received from the president is subjected to an eligibility test by the IEBC. And the president, rightfully so, in his forwarding letter to the National Assembly, did indicate that he got clearance from the IEBC. Very elaborate. But then there's a question that's set somewhere here in between. What is the IEBC today? Do we have an IEBC that can perform the functions of that particular commission? The answer is no, because we do not have commissioners in office. And even the IEBC itself, the current acting the CEO, Mr. Marjan, for those Kenyans who after the Gen Z revolution had petitioned for recall of members of parliament, he specifically told them in a letter dated, I think sometimes in July 2024, that you cannot, the IEBC cannot authorize the process of collection of signatures for recall petitions because there is no chairperson and there are no commissioners. And the Supreme Court of Kenya in the BBI case discussed the question of what constitutes IEBC and whether the IEBC can function without commissioners. And the Supreme Court said it cannot perform the functions of the commission without commissioners. So what am I saying here? Our courts have read themselves on some of these questions. Until this point, the courts have spoken on the question of whether Kindiki should be the deputy president at this point. They've said no, hold your horses. And the test is now moving to Martha Koome. Because also for the swearing in of the deputy president, it has to be done in the presence of the Chief Justice. It is the registrar of the judiciary, chief registrar who administers the oath, in the presence of the Chief Justice. Martha Koome must resist any attempt that may be put on her to attend to any swearing in of Koome, of Kindiki, in light of the existing court orders. She must show the nation that the institution that she leads, she also believes in its orders.
Hold that thought, and I know Dr. Maxwell has a different opinion on that particular issue. Let's just take another break. We'll be back.